What is up, everyone? Welcome back. So today we have some updates, finally. Yes, I know some of you have been waiting. I apologize for the delay, but here we are. We got a couple updates regarding the ZeRo case. I don't have the latest filings because a lot of it is just case management conference stuff, after the fact. That is pretty uninteresting. But there has been some interesting filings regarding the CMC that you see before you here. So we'll be going over this. I might have the franchise on here in a bit, and whoever else ends up joining the stream. But I'm going to be going over this, and then I'll be going over Jisu's answer that she filed with her lawyers. So it's pretty interesting. The filing has some pretty interesting stuff in it, and I'll give my opinion on it once we get to that point, because before, if you guys remember in the previous stream where I went over some of this stuff, I felt that a settlement could be on the horizon from the way that the CMC was laid out. It seemed like, the lawyers got together and they talked about some stuff, potentially seeing if it looked like that's where I was heading, where it looked like they decided during the case management conference seemingly to hear each other out. And it looked like it was potentially heading towards a settlement conclusion. But I have to say, after looking over some of these documents, I'm not sure if that is going to be what unfolds, because there's some interesting stuff in here. Like I said, we'll go over all of it, though. So here's the this is the case management conference statement. This is the one that was filed by Jisu. I think the one that we went over before was filed by ZeRo. I can't remember. It could have been by Jisu. I don't know. But this one was filed by Jisu. It's about 6 pages. We'll go over it here pretty quickly, and then we'll get into the juicy stuff, right, which is the answer. There has been a hearing. There is going to be another hearing, from my understanding, I think in September. So there has been some filings for, extensions on stuff, for like attorney's fees and stuff like that. We'll kind of briefly go over that as well, because I got that too. But we'll go over this first and foremost, which is the case management statement from Jisu here. So as you can see, it's the information here, lawyers and all that. We see here unlimited case, because of the amount for damages obviously exceeds the $25,000. Statement is submitted by party. Jisu there. Then we go on to see type of case: complaint, intentional infliction of emotional distress, dismissed. Let's see. And then we see here, right, jury or non-jury trial, which is, and we saw this before, and this is probably not going to be too different from the case management conference statement that we saw before. Obviously, a request of a jury trial. No trial date has been set. The party or parties estimate that the trial will take, 5 to 7 days. Then we have trial representation by the attorney of party listed in the caption. So obviously, this is showing that she has an attorney for parties represented by counsel, which again is something that she has. Plaintiff petitioner Gonzalo Barrios, defendant responded Jacqueline Chope. Then we see here mediation not yet scheduled. Then we have the settlement conference not yet scheduled. At the time of the filing of this, which was earlier in July. We're past that now, so they might have already, I think they probably already had met at this point, maybe not. But then we have, jurisdiction and insurance related cases. Like I said, pretty much a lot of this is the same as we saw before with the previous case management statement. The following discovery will be completed by dates specified. So we see here written discovery. It's set, to be that's set to be completed by December 20 of this year. Then we have depositions that's set to be completed by February of next year, and expert discovery that's per code. And we go on here. So again, a lot of this is it's a lot of the same stuff from what I'm seeing here. Then we have we see here the filing, but we're going to get on to the good stuff here now. The good stuff. which is this next part here. What's up, Solid Redfield? How you doing, buddy? Let's see. Let's get on to the answer to the complaint, okay? Because this is where there's a lot of really interesting stuff, okay? So this is Defendant Jacqueline Cho's answer to plaintiff's first amended complaint. You know, pursuant to California Code of Civil Procedure, section 431.30, Defendant Jacqueline Cho hereby generally denies each and every allegation in the first amended complaint, and further denies that plaintiff Gonzalo Barrios has been damaged in any sum whatsoever. Any further answering the FAC, and by the way of affirmative defenses, defendant alleges as follows. Now, it's interesting, right? Because she said, you know, the lawyers are basically saying, hey, this didn't hurt him in any way, when we know that he lost basically his his sponsorship, right? With the team that he was a part of. We know that. So that did happen. And apparently that happened as a result of these allegations. Now, it's going to be a matter of, you know, proving that, of course, you know, it's going to be, you know, ZeRo having to prove that with what he has. But as a result of these allegations, yeah, I mean, I think it's fair to say there were some damages. He had a Facebook partnership deal, I believe, that was also lost, if I remember correctly, on top of him basically parting ways with the team that he was a part of, right? And whatever other sponsorships or any kind of deals that were tied up with that also went away. So we have the first affirmative defense, statute of limitations, the FAC, and each and every cause of action therein is barred by the applicable statute of limitations, including but not limited to California Code of Civil Procedure. Now, in fairness to what is being said right here, okay, remember that the judge that was presiding over the, you know, when they first had the first hearing, right, the judge that presided over it did find that the complaints were past. A lot of the complaints were past the statute of limitations, with the exception of the one where where she basically called ZeRo a pedo, right? That was the one that she was like, okay, well, this isn't past statute of limitations. So this is still basic. This cause of action is still good, essentially. You know, the other ones were ignored, but that one was the one that went through. And that was, remember, that one was as a result, that's the one that's tied to the whole, you know, Katie debacle, right? So obviously not everything is past statute of limitations. That's just not true. The FSC fails to state sufficient facts to state any cause of action against defendant. I don't know about that, especially considering the fact, and we've talked about this before, right, that on more than one occasion, right, Jisu has called ZeRo a pred and a pedo, right? That's happened on more than one occasion. That's even happened after the fact, right? When she found out ZeRo was suing her, she basically called him a pedo in her tweet, which I believe is still up. And if you remember, there was also the GoFundMe page that she set up, right? Where she basically reiterated those same sentiments on the GoFundMe page that she had to change. So, because it got taken down. So here we have third affirmative defense, truth. Plaintiff's claims for defamation must fail because any comments attributed to the defendant were not false. What? How do you determine this? I mean, these lawyers, man, her and these lawyers, they're swinging for the fences, right? They were not false. They're going with that. It's just like you can't prove that they're true either. So good luck with that. This is another interesting one too right here. Fourth affirmative defense, lack of malice. Okay. Plaintiff's claim for defamation must fail because plaintiff is a public figure with respect to the subject matter of the statements at issue in this lawsuit. The statements concerned a matter of public interest and are privileged, and any comments attributed to the defendant were made without malice, hatred, or ill will, and were not made with knowledge of their falsity or in reckless disregard with respect to their truth or falsity. Bullshit. Bullshit. Okay? That's absolute bullshit. And the thing is, even if she thinks, right? Even if Jisu thinks that what she said was not malicious, I was just stating, because remember, we've heard that from her before, right? I didn't make up these rumors. I just repeated them. She has said that before. Remember? That was one of the things she said in a previous filing, right? I didn't make up these rumors. I just repeated them. So that's okay. I just spread them. I don't know if they're true or not. I just spread them. Now we have fifth affirmative defense. If plaintiff sustained any damages as alleged in the FAC, such damage was approximately caused and contributed by plaintiff's failure to mitigate damages. Plaintiff's failure to mitigate damages diminishes any recovery herein. How do you figure that? Right? Because I think there's a direct correlation, right, of all the things that ZeRo lost as a result of these allegations coming out against them. Okay? like you said, like this filing, I read through a little bit of it earlier, and I was just laughing because I was like, they cannot be serious. They cannot be serious with this. It's like, are they really gonna, you know what I mean? Are they really gonna like put on the blindfold and just spin around in a circle and just point randomly? It's just like, really? Are you really gonna do this? It's just like you just gonna Hail Mary this shit? I mean, look, ZeRo's not guaranteed a win in this case. Anything can happen. That's the thing with any kind of court case, but especially defamation cases, right? They're very hard to prove and they're very hard to win. But you have, in this particular instance, I think it's fair to say, and objectively speaking, I think it's fair to say that there was some malicious intent here, legally or otherwise. Okay, because there's a legal definition for malice, and obviously we know that there's, you know, the actual definition of malice, right? So I think it's fair to say that objectively speaking, at least one of those, if not both, had to be true. Okay. And the thing is, like I said, look, this could go to trial and he could still end up losing. This could end up being, it's still at that point where it could end up being dismissed as well. But I don't know, man. I don't know, especially considering her actions after the fact. I think that only helps strengthen the case against her. So here we have sixth affirmative defense, estoppel, right? Defendant is informed and believes and based therein alleges that plaintiff has engaged in conduct and activity sufficient to stop him from asserting all or any part of the claims set forth in plaintiff's FAC. I mean, I think that'll really be up to a jury to decide. And like I said, given what we've seen publicly, right? I mean, I think he's got something. I think he's got a fair chance. But again, there's no way to know for sure. He could end up, you know, this could end up going to a jury trial, and depending on who's a part of that panel, it could end up not going his way. Like I said, it might not even make it there. You know, when I was talking about this last time, I really felt, you know what? Maybe there will be a settlement. It's possible that a settlement is very likely now because both parties are open to it. Both parties are open. They seem to be open to speaking. But man, I don't know how ZeRo's lawyers are going to see this filing and be like, yeah, let's make a deal. You know what I mean? Let's make a deal. This, you know, I don't know that'll happen. Because it seems to me like, especially from reading this filing, Jisu and her lawyers are willing to die on this hill. So I don't know. I mean, it's still within the realm of possibility that a settlement could be reached. But I would think that ZeRo's lawyers looking at this, they must have laughed, right? So man, her best bet, honestly, is still to settle with him, because she's not going to be able to draw it out in court with him. She's not going to be able to outspend him in court. You know, it's just not. I don't see any scenario where she's going to really be in it for the long haul. Who knows, especially with how much activity there's been with the filings and stuff like that so far. I don't know how much of that GoFundMe money she's already burned through, right? She raised something like 12 or 13,000. I mean, it might be still enough to do all these filings and stuff like that. But for it to drag out into an actual jury trial and things like that, it's just not going to be enough. It's just not going to be enough. So her best bet is to settle, in my opinion. But you see a filing like this, and it's just like, really? Like, is this the hill you really want to die on? But then we have a 7th affirmative defense waiver. Defendant is informed and believe and based therein alleges a plaintiff has engaged in conduct and activity sufficient to constitute a waiver of any claims or cause of action he may have had against defendant. No, I don't think so. No, I completely disagree with that. Completely disagree with that. Then we have ninth affirmative defense, right to free speech. Oh boy, here we go. Here we go. Defendant is informed and believes and based therein alleges that plaintiff's claims are barred in whole or in part by Cal Code Civil Procedure 425.16 because such cause of actions arose from defendant's furtherance of a right to free speech under the United States of California Constitution in connection with the public issue. Right to free speech does not cover defamation. It doesn't cover threats, and it's not something that's covered by it's not something that covers defamation. So calling the man a pedophile, besmirching him, publicly with allegations that has, as of yet, right, as of this time, have not been substantiated. We just have one side. I mean, haven't been thoroughly substantiated, I should say. So then we have, all right, 10th affirmative defense. If plaintiff sustained any damages as alleged in the FAC, such damage was approximately caused and contributed by plaintiff's failure to conduct himself in a manner ordinarily expected of reasonable, prudent persons in the conduct of their affairs and business. The contributory negligence and fault of plaintiff diminish any recovery herein. So it's basically, hey, listen, anything that happened to ZeRo is his own fault. Look, it's fair to say that he's partly to blame, right, for certain things that have happened, right? Certain things that have happened. I think it's fair to say that ZeRo admitting to then walking back stuff that is kind of on him, whether it's true or not, right? He should have just outright denied everything. But at the same time, again, we've talked about this before several times when we've discussed ZeRo and this court case and things like that. You can't expect an irrational person to think rationally, especially in moments of stress and intense duress, things like that. They don't think rationally, especially when you think about the fact that the guy not only, he claims he wanted to off himself, and months after that, he apparently did attempt to off himself. So again, he's a person that seems he has these moments, right? He has issues that he's completely irrational, and we're trying to ascribe like rational thought to a person that doesn't think rationally. So, defendant is informed and believes, 11th affirmative defense, unclean hands. Defendant is informed and believes and based therein alleges that the claims and relief sought by plaintiff is barred by reason of the doctrine of unclean hands. That's something that I need to brush up on again, what that means, because I've seen that before. We looked over that stuff with the PvP court filing as well, his answer to his lawsuit. So defendant is informed. Okay, 12th affirmative defense, consent. Defendant is informed and believes based therein alleges that the claims and relief sought by plaintiff is barred by reason of consent. 13 affirmative defense, absolute constitutional and qualified privilege. Defendant is informed and believes based therein alleges that the claims and relief sought by plaintiff are barred because defendant's actions were protected by the common interest privilege and fair and true reporting privilege, the judicial proceedings privilege, and any other applicable privilege. Yeah, no, I don't think so. I don't think that you can say that that would be something that would be protected under that, because again, we don't know for a fact that anything that Jisu reported in regards to the serious allegations against ZeRo are true. We don't know what's fact and what's fiction in those instances, right? Again, I know that there was a lot of people that were like, well, he must have done it because he admitted to it. Yeah, but then he walked it back, along with other things that he admitted to and also walked back. So these are things that, this is a pattern of behavior with him in that regard, where he's admitted to things that he hasn't necessarily done, and those things, the things that he admitted to and walked back seem to be, there seemed to be more compelling evidence to suggest that, those things were just not true. So again, it's one of those instances where the lines are so blurred. I mean, we don't know what's true and what isn't true. And the fact that, again, nothing has been thoroughly substantiated with any kind of hard evidence, it's still, it's up in the air. I don't think that you can call that, that would be something that I would think that this privilege, right, this true reporting privilege would be covered under, because we don't know that it's true reporting. So that any of it is true. So yeah, we have 14th affirmative defense, no causation. If plaintiffs suffered damages in any amount whatsoever, any and all such damages were caused by persons or entities other than defendant, whom defendant has no control and for whose actions defendant is not responsible. Oh, come on. We know better than that. Who signal boosted that, right? Who made the rounds with the ZeRo thing, right? Jisu absolutely put that into a much bigger spotlight, right? She went on live streams. She did, stories were written about it where she was directly sourced, right? The reason why it got as much traction as it did was because of her. There was other people, of course, that helped, perpetuate it. There was other people that helped signal boost it. But let's be serious here, right? Let's be honest here. She was the one that spearheaded the thing. She spearheaded the whole thing. So, yeah, no. All right. It says, let's see, 15th affirmative defense. Plaintiff's damages, if any, are too speculative to be recoverable at law. I don't know about that. I think you could pretty much, I'm pretty sure they're going to be able to narrow down a fairly accurate estimate of what ZeRo lost, right? I'm pretty sure, especially once, especially if he shows like his contract with Facebook Gaming and whatever contract he was under with his team, with the esports team that he was a part of. I think they'll be able to to give a pretty good estimate on top of, again, whatever other sponsorships that he had, right? Whatever sponsorship agreements that he had. So BMA Joey says she literally had an open goal with just called out the one who abused her. Why would Jisu then go after Sky and ZeRo? What the fuck is wrong with people, man? That's the thing. They just want to see the world burn. I mean, they want to have their moment, right? They want to have their 15 minutes. They want to feel like they're making a difference, and the way they do it is, again, the most minimal way possible. You know, getting online, typing out a Google Doc, tweeting, doing things like that. 16th affirmative defense, additional affirmative defenses. Defendant reserves her right to raise and plead additional defenses and or affirmative defenses which might become known during the course of discovery, as well as to dismiss any defenses which, as a result of discovery, are determined to be unsupported by good faith reliance upon either the facts or the law, or non-frivolous argument for the extension, modification, or reversal of existing law, or the establishment of new law. Interesting. So that's basically, and I could be wrong, but the way I interpret that is, she basically whatever comes up through discovery, it's basically like, reserving her right to defend herself on what comes out through discovery. That's going to be very interesting to see what comes out of discovery. Wherefore, defendant Jacqueline Cho prays as follows. The plaintiff takes nothing by way of his First Amendment complaint on file herein. The judgment be entered in favor of defendant for cost of suit and for such and other further relief as the court may deem just and appropriate. Good luck with that. Good luck with that. Because that's, man, unless your lawyer is, has got the Midas touch, good luck with that. Because I don't think that that's going to happen. But hey, I could be completely wrong. You never know how these things are going to go. They could end up completely siding with her. So the last thing I'm going to go over here is this extension here. So we'll go over this here real quick. So this is just a joint stipulation to extend time to file motion for attorney's fees costs regarding defendant's special motion to strike proposed order. So we'll go over this real quick. And then by then, I think the franchise will be here and we'll just discuss this a little bit. And then we'll go ahead and close out the stream for the night. I just want to thank you all for joining me, though, but we'll go over this here real quick. So this here says, plaintiff Gonzalo Barrios, by and through his attorney, plaintiff and defendant Jacqueline Cho, by and through her attorney, defendant, hereby stipulate and respectfully request that the court extend the time for any of the parties to file a motion for attorney's fees relating to the ruling of defendant's special motion to strike August 15th, 2022, whereas plaintiff filed his original complaint on November 19th, 2021, whereas on January 24th, 2022, defendant filed her special motion to strike under Code of Civil Procedure 425.16, whereas on March 9th, 2022, the court issued its ruling on the defendant's special motion to strike, partially granting the special motion to strike, whereas on March 24th, 2022, plaintiff filed and served his amended complaint, whereas the defendant intends to file a motion for attorney's fees for partially prevailing on the special motion to strike. So that's regarding the that's obviously regarding the anti-slap, right? Whereas on March 24th, 2022, plaintiff filed and served his first amendment. Okay, whereas defendant intends to file a motion for attorney's partial. Okay, we're actually on this part. Whereas the court granted an extension of time for defendant to file an answer through July 10th, 2022, and a motion for attorney's fees for the special motion to strike through July 13th, 2022. Whereas the court set a case management conference for July 11th, 2022, whereas the parties have a settlement in principle that they are diligently working to memorialize in a written settlement agreement, but require an additional 30-day extension of time to finalize. So basically, they're still going to try, it seems like, to reach a settlement, but I don't know, man. I mean, and again, that would be the ideal situation for Jisu. I don't think that she wants to try to fight this out in court. I don't see any upside for her, especially her losing on the anti-slap. So we have here, whereas the course, okay, let me see, whereas incurring additional legal fees and further burdening the court with a motion for attorney's fees would waste judicial resources and hinder the finalization of settlement agreement by increasing legal fees and costs, whereas defendant will file her answer by July 10th, 2022, in accordance with the court's order, but reserves the right to request leave from the court to file a cross complaint if the parties are unable to finalize their settlement. Whereas California Rules of Court Rule 3.1702D provides that for good cause, the trial judge may extend the time for filing a motion for attorney's fees in the absence of stipulation for a longer period than allowed by stipulation. Whereas the trial date has not been set. Now, therefore, plaintiff and defendant hereby jointly stipulate and request the defendant deadline to file a motion for attorney's fees and costs and special motion to strike is extended to August 15th, 2022. It is so stipulated, and we're already past that date, obviously. So we might be getting, we could be getting word here soon on whether or not, an agreement has been reached. Having considered the joint stipulation to extend time to file motion for attorney's fees, costs, joint stipulation filed by defendant Jacqueline Cho and plaintiff Gonzalo Barrios, collectively the parties, and good cause appearing therefore, the court orders, one, the parties' joint stipulation is hereby granted. The deadline to file a motion for attorney's fees for defendant's special motion to strike is hereby extended to August 15th. It is so ordered. So there we have that. So not anything too major there, but it's looking like they're still in that mode of trying to settle, seeing if they could come to some kind of settlement agreement. And I don't know, man. Again, it does seem like the most likely outcome, kind of still, but I don't know. Seeing like what the answer was before and how, again, it seems like she's willing to die on that hill. It makes me wonder what it is that her attorneys are going to, what will be an acceptable settlement on their side, right? What they'll agree to in order to basically put an end to this. And I don't know, from the way it reads, from the way her answer reads, it sounds like, she really believes all the stuff, right? Oh, Franchise is here. Hey, what's up, buddy?
Yo, what's up, dude?
Welcome.
What have I missed?
Oh, no. I was just going over the stipulation for like the extension and stuff for them to potentially, for the settlement and all that stuff, for them to have time to file, their attorney's fees and all that stuff. So it looks like, for the most part, it looks like, things are still in that. It looks like they're still both looking to settle.
Yeah, that's what I've heard.
Yeah, but when you read the stuff I was reading before, right, with her answer, I'm just kind of like, it makes me wonder what it is that her attorneys are going to be expecting, what their conditions are going to be for settlement, right? Like, well, we'll settle if he says this or he does that, right? So
I know for like lawsuits, you have to file an answer, or else like they can give like a special ruling or something. I'm not sure.
Yeah, I think they could give a default judgment.
Yeah,
I believe.
So yeah, but she obviously had to file an answer. So
yeah, it's just interesting how it reads though. Like, did you see this?
Packed it with like so much.
Yeah, dude, it's just, for me. I laughed at some of it because I'm like, you've got to be kidding, right? Like, I don't know if you caught when I was going over the first affirmative defense and all this stuff, or if you were in and out. But we could go over it again here real quick now that you're here, and because I'd like to know like your thoughts on it. So I'll just go over this again real quick now the franchise is here, so you guys could get a fresh perspective on it. But here's her answer. So, pursuant to California Civil Code of Procedure, Section 431, .30. Defendant Jacqueline Cho. Defendant hereby generally denies each and every allegation in the First Amendment complaint, FAC, and further denies the plaintiff Gonzalo Barrios has been damaged in any sum whatsoever. Further answering the FAC and by way of affirmative defenses, the defendant alleges as follows. What do you think of that just right off the bat? It's just like he wasn't hurt at all by this. To put it. Yeah, he wasn't hurt at all by this. Hasn't been. So the first affirmative defense, statute of limitations. The FAC and each and every cause of action therein is barred by the applicable statute of limitations, including but not limited to the California Code of Civil Procedure 340.
She's lucky on this one.
Yeah, because
the actual claims that expired were the ones regarding Vanessa, which she admitted to being false.
Yes.
So this honestly is like this saved it from being like bad, from being really bad to just bad for her.
Yeah. Well, remember the stuff that stuck was basically the Katie stuff, the Katie allegations. You know, that's the thing that stuck, and it's just like, and that's the most egregious, claim against him. So then you have a second affirmative defense, failure to state a cause of action. The FAC fails to state sufficient facts to state any cause of action against defendant. And I was just like, yeah, I don't know about that. I think it's pretty sufficient when you're out there calling a guy a pred or a pedo. You know what I mean?
Mm-hmm. Yeah.
So then you have third affirmative defense, truth. This one is the one that really, like, I was talking with Aura earlier about this, and this is the one that really made me laugh. Plaintiff's claim for defamation must fail because any comments attributed to defendant were not false. And I'm just like, how do you figure? It's like you don't know if they're true either.
Oh my god.
I was just like, what? I was like, wow. Yeah. Fourth affirmative defense, lack of malice. Plaintiff's claim for defamation must fail because plaintiff is a public figure with respect to the subject matter of the statements at issue in this lawsuit. The statements concern a matter of public interest and are privileged, and any comments attributed to defendant were made without malice, hatred, or ill will, and were not made with knowledge of their falsity or in reckless disregard with respect to their truth or falsity. What do you think of that, franchise?
See, just imagine if, the other claims that were struck because of the statute of limitations, imagine if those were, able to stand.
Oh, bro, forget about it.
This would have been... Because, she posted the tweet about their ages, on the 3rd, and everybody was like, oh, this is false, you gotta, stop. And then... Yes. And she had the resources and, the ability to just search up the ages, but she didn't. And then 2 days later, kept pushing it.
Yes, bro. You know what's crazy to me, right, is them saying that it's with respect to the subject matter, public interest, they were made without malice, hatred, or ill will. They might have been made without hatred. They might have. You might even be able to argue they were made without ill will, but malice, I think it falls. See, because there's the definition of malice, and then there's the legal definition of malice. I'm like, it definitely falls under one, if not both of those. So I'm like, yeah, no. Or in reckless disregard.
The reckless disregard part.
Yeah, yeah. Oh, bro, if the Vanessa thing had stuck, it's done deal. Done deal. Because the other stuff, again. GG. Yeah, the other stuff, I mean, you could make the argument for, because, again, there's, unfortunately, because of him admitting to, but then walking back, that's where you have a little bit more of that wiggle room to possibly argue that. But with the Vanessa stuff, which was 100% false, 100% false, it's just nah. She
had every opportunity to retract it. She knew it was false, for days, kept pushing it, didn't bother asking or confirming anything. So it's both with ill will and with reckless disregard.
Yes,
she's just so lucky that it was struck down because it was over a year old. Yeah,
really. GG Evans, thank you for the 5, buddy. ZeRo isn't a pedophile. Vito Gasoli, maybe. Welcome back, John. Thanks, buddy.
Bro, my next video, I'm making a video about Ace Attorney, and then my next video is going to be about Edwin. Oh, nice. And I'm watching through his streams with one of his streams with Vito, and it's so bad.
Oh God.
He's like,
I'm,
man,
I'm sorry that you have to come over all that stuff, man. That you have to go
I had
over.
to watch hours upon
It's
hours
brutal,
of
man.
it.
I've had to do that
Hours
too, man.
upon hours of that one, dude. My
Yeah.
brain has rot.
Oh, man, that's rough, man.
Like,
bro, let me
he
tell you, bro,
almost
you're a
started
stud.
making sense. That's how
Oh,
bad it got.
bro, you're a stud for doing that, man. You're a stud. I cannot sit through people's videos that I just that I just can't stand. But I've done it before too, man. For the purpose of
Yeah.
research
You
and
got to
stuff.
do
I've
what
done
you
it.
got to do.
Yeah, you have to throw down. You got to throw down. So check this next one out, bro. If plaintiff sustained, all right, so there's the fifth affirmative defense, right? Failure to mitigate damages. If plaintiff sustained any damages, as alleged in the FAC, such damage was proximately caused and contributed by plaintiff's failure to mitigate damages. Plaintiff's failure to mitigate damages diminishes any recovery herein.
Bruh. Didn't she earlier say like that he suffered no damages?
Yeah. Well, no,
Like,
that's something that I think that's something that was said earlier, and I think it's also said in one of these other affirmative defenses as well. I think it's reiterated
Yeah, because
in one of these
usually
other
in
ones.
like a lawsuit, when you say something like that, like any damages were his fault, it would also like before that come with the caveat, like we still maintain that there were no damages, but if he can prove damages, then it was his fault. That's normally how it's worded. I don't get why they didn't do that there.
Yeah, it is pretty strange. So here's the next one. This is the sixth affirmative defense. It says, defendant is informed and believes and based therein alleges that plaintiff has engaged in conduct and activity sufficient to stop him from asserting all or any part of the claims set forth in plaintiff's FAC. And again, I don't know about that, but I mean, hey, argue what you got to argue. Seventh affirmative defense. Defendant is informed and believe and based therein alleges that plaintiff has engaged in conduct and activity sufficient to constitute a waiver of any claims or causes of action he may have had against defendant. I'm like, nope. I don't think so. I don't think so. I don't think so. But again, good luck. Eighth affirmative defense. Defendant is informed and believes and based therein alleges the plaintiff has waited an unreasonable period of time to complain of the alleged acts or omissions at issue in the FAC so as to prejudice defendant. Plaintiff is therefore guilty of lashes. Is that like lashes? I believe that's how. I think it's either
Lashes, it's something.
lashes or something. Maybe it's lashes. I don't know. And is barred from recovery. I'm like,
that one makes no sense. Like, it's already only a year for statute of limitations.
Yeah, that's what I mean. I mean,
it's like,
look,
why does this exist if there's already a statute of limitations?
Yeah, I mean, I mean, look, he did it, I think, as quickly as he could, as was feasible for him. Mm-hmm. I guess it's just like, I mean, what do you want? I mean, do you want him to file it sooner? I mean, maybe he was just getting what he could.
Yeah,
maybe he should have.
Didn't have the evidence.
Yeah, he probably didn't have what he needed, or that. Yeah, you don't know why he didn't. Yeah. Maybe he could have filed it sooner. Who knows? But
and it's still within a year, so it's of at least the Laura and Katie stuff. It's still within a year, so I don't see why. I don't get why this is a defense if there's just statute of limitations.
Yeah, it's weird. And then you have the ninth affirmative defense, right to free speech.
She might be right on this one.
See, so defendant is informed and believes and based therein alleges the plaintiff's claims are barred in whole and part by the California Code of Civil Procedure 425.16 because such causes of actions arose from defendant's furtherance of her right to free speech under the United States of California Constitution in connection with a public issue. See, here's the thing: the problem with this, though, right? And this is why she didn't win on anti-slap, because basically this would have anti-slap. Part of it is this, right? Is right to free speech. Mm-hmm. The thing with this is free speech. Defamation is not really something that's covered under free speech. It's like those are the things that aren't covered under free speech. Is like, threats, and incitement of violence towards someone, as well as defamation is one of those things too.
Libel.
Yeah, that's not something that is. So, 10th affirmative defense, comparative fault. If plaintiff sustained any damages as alleged in the FAC, such damage was proximately caused and contributed by plaintiff's failure to conduct himself in a manner ordinarily expected of reasonable, prudent persons in the conduct of their affairs and business, the contributory negligence and fault of plaintiff diminish any recovery herein. So this one's not, look, this one's not a bad argument to make, right? Because there is, I think it's fair to say, and I said this before you got here, and maybe you'll agree with me, maybe not. ZeRo is partly responsible for this, for what kind of happened publicly. He should have
lose like his sponsors and stuff before he confessed, though.
I believe so. From my understanding, that's my understanding from at least from what Technicals has put out there. My understanding is that prior to he had already lost, like prior to him making his public statement, he had already lost his sponsorships and stuff. And he had lost his Facebook deal. He lost his spot on his team. Now, we'll know for sure once, like, if that all comes out, right, during discovery, that's how we'll know for sure. But that's what's claimed. What's claimed is that he did lose all that stuff before he finally was like, yeah, all that stuff was true after the fact. And that's where I think he's kind of at fault in that regard. He probably shouldn't have said nothing. Probably should have just stayed quiet. But, the guy was under some kind of duress. So again, not trying to make excuses for him, because the thing is, again, I don't know how his mind works. I mean, I'm just saying that's what he had claimed, right? Is that he was in a bad place. So 11th affirmative defense, unclean hands. This is one that always I'd looked this up before, what unclean hands is, but I'm not exactly brushed up on what exactly that means. But defendant is informed that believes that alleges that the claims and relief sought by plaintiff is barred by reasons of doctrine of unclean hands. Then we have 12th affirmative defense consent. Defendant is informed and believes, and based thereon alleges that the claims and relief sought by plaintiff is barred by reason of consent. Then we have 13th affirmative defense, absolute constitutional and qualified privilege. Defendant is informed and believes, and based thereon alleges that the claims and relief sought by plaintiff are barred because defendant's actions were protected by the common interest privilege, the fair and true reporting privilege, the judicial proceedings privilege, and any other applicable privilege. See, this one I don't agree with, because I'm just like, I don't know if that applies in this particular instance, because the stuff that you can't say that any of the stuff that Jisu reported was factual. You know what I mean? Yeah. There's no way to know. So it's just like, would that really fall under a true reporting privilege if the stuff that's being reported has not been substantiated?
Yeah, basically.
So it's like, I don't know if that, you know what I mean, if that would apply in this particular instance. So you have 14th affirmative defense, no causation. If plaintiff suffered damages in any amount whatsoever, any and all such damages were caused by persons or entities other than defendant. Bullshit. Over whom defendant has no control and for whose actions defendant is not responsible. Now, I said this before. You got here. Bullshit, right? Because there was other people that did signal boost it, right? But make no mistake, she was the one that spearheaded this shit. Is that fair to say, franchise? Like, objectively speaking, am I wrong?
That's not even fair to say. That's just objectively correct.
Mm-hmm.
She spearheaded it.
Yeah, she's the one that went to all the different websites. Remember, she went on a couple live streams too, didn't she?
Yeah.
If I remember correct. Like, talking about this on
went
panel.
To every journalist, went to several panels.
Yeah.
Went to Dr. K.
Mm-hmm. Like, she went to all these different people. She made the rounds. Like, signal boosting this herself and spearheading this effort. There was other Smash players that might have, retweeted her and signal boosted it. And may have said they're, we know Leffen, of course, right?
Yeah.
Leffen was fully on board with getting this put out there. But she was the one. She was the ringleader.
Yeah.
She was the one really pushing for this. It's just like, no. She was like
ZeRo and Sky.
Yeah. Yeah, man. It's just like, no, that This is 15th affirmative defense. Plaintiff's damages, if any, are too speculative to be recoverable at law. It's like, that I don't know about that either, because I think that once, and I'm pretty sure I'm pretty sure if ZeRo shows whatever contracts he had with his esports team and his sponsorships and his Facebook deal and all that, I'm pretty sure they're going to be able to narrow down a pretty rough estimate.
Yeah.
I don't think there's going to be any speculation there. Yeah, there's not going to be anything speculative about the amount. I mean, the only thing that maybe potentially could be speculative is the sponsorship deals over, how long those would be over the course of how many years. I think if the contracts have a set amount that's stated per year basis, that's going to be pretty concrete. There's no room for speculation there. Now, sponsorship deals, though, I think that's a little different. I think those could change to more or less depending on on however long you're with those sponsors and things like that, and how often you're putting that out there, right? Putting their stuff out there. So that might be a little bit more, I guess you could say, speculative, but contracts with an esports team, especially for X amount of years, hey, we're going to pay you this amount for this many years. I think that's going to be pretty concrete. So, and who knows, maybe it could be even more, right? If over the years hey, first year we're going to pay you this, depending on how you do, we might raise it to this, which I don't think they would necessarily put that, but who knows? Mm-hmm. Maybe there's contracts out there that have that hey, over the course of so many years, we're going to up you this much percentage or whatever. So, we have the 16th affirmative defense here. Additional affirmative defenses. Defendant reserves her right to raise and plead additional defenses and/or affirmative defenses which might become known during the course of discovery, as well as to dismiss any defenses which, as a result of discovery, are determined to be unsupported by good faith reliance upon either the facts of or the law, or a non-frivolous argument for the extension, modification, or reversal of existing law or establishment of a new law, which, I mean, that would be expected, right? Because once discovery is done and it's put out there, if unless they reach a settlement beforehand and they don't get to the point of discovery, obviously, yeah, you would expect somebody to be like, to defend themselves against, any additional things. So here's the prayer. Wherefore, defendant Jacqueline Hill prays as follows: the plaintiff takes nothing by way of his First Amendment complaint on file herein. To the judgment be entered in favor of the defendant for cost of suit. I don't think that's going to happen, but it could, because again, defamation cases are pretty tough. And for such other and further relief as the court would deem just and proper. So there we have that. So, what are your thoughts on that, my friend?
It's a legal document. That's the only way to put it.
Yeah, man. I just think that, like I said, looking at this, I'm just like, well, it seems like my biggest takeaway from her answer is that if for whatever reason they don't reach a settlement, it just reads as she's absolutely willing to die on the hill. You know what I mean?
That would be funny. I'm pretty sure she just doesn't have any money right now.
Mm-hmm. Well, was it you? I think it was you, right? You had tweeted out that she was like at a convention recently, after saying that she was done. Oh, was it technicals?
She had she had a booth. I think she had like a booth set up there. I don't think she was physically present, but she had something set up there.
Interesting. So she paid somebody to be there for her, then sell her art.
Yeah, I'm not sure, but there was Jisu. Jisu had something there.
Interesting. I mean, hey,
Con.
I mean, you got to do something, right? You got to raise that money because, I mean, like I was saying before, she raised something like what, $12,000, $13,000, and like I said, I don't think, yeah, but not even, right? It was less than that.
It was about 12,000, not quite 13 though.
Yeah, I don't.
It was somewhere in the middle.
Yeah, I don't. That's not going to be enough for her to fight anything out in court. She might be able to use it as far as like getting past if it goes that far, if it goes to depositions and things like that, and maybe a little bit more than that. But I don't know, to fight out a lengthy court battle with ZeRo. Yeah, I don't think so.
Mm-hmm.
So
Speaking of money, apparently Jisu's new like NFT project, like Chibis or whatever,
Mm-hmm.
like we were going over this in Discord, me tech and some other guy. It might like actually be a scam.
Wow. Could
Like
you
obviously
imagine?
like NFT scam, whatever, but like we were going through the crypto wallets
Yeah.
of like Jisu, and it, the day after I think the project went live, like she sold that like sold like the project rubbed basically
Wow.
allegedly.
That's
They
interesting.
got to run you. Yeah,
Could you imagine if on top of everything else, like if she was a part of some exactly if that did turn out to be some some scam and stuff like that, and she had been scamming a lot of people out of money, like that's the last thing you would want right
yeah.
now, right?
Many people
Especially
are
given
like
the position you're in.
really upset. Many people are like really upset with the project. I tried joining the Discord, and the links just don't work anymore. So I'm not sure if the Discord like doesn't exist or if the links are expired. But
Wow.
it's crazy.
That'd be some shit, man. Like I said, on top of everything else, it's just like you got this lawsuit going, right? Where you're seemingly trying to settle because that's really the only that's going to be your best
That's her only
recourse.
option.
Yeah, that's going to be your best recourse at this point because you don't have the money to fight a lengthy court battle with this guy, and it's not worth rolling the die. I mean, again, she always has a chance because you just don't know how people you just don't know how these court cases are going to go. They could end up siding with her, but why even take that chance, given the fact that you're already off to a bad start. You don't have sufficient funds to really battle it out, and like what you just told me right now, right? You have possibly a scandal looming over your own head if this ends up being something that is bigger than what anybody knows, right?
My favorite part about it is like she wrote like a retrospective or reflection on her first NFT project, and she's like seeing the market crash. She was having like multiple mental breakdowns and like contemplated suicide. And it's like, okay, I'm sorry your scam wasn't gonna make as much money.
Oh my god!
It's like it's so obviously sympathy baiting because it's like
Yeah,
behind the scenes you look at like all the charts and the graphs and all the transactions and you're like, what's going on? There's like multiple different wallets involved, like a large amount of money just being thrown around randomly. It's like,
bro, that is some shit, man. Look, I try not to, I don't wish I don't try to wish people ill will, but the thing is, in
yeah,
situations like this where you have somebody that
there has to be consequences of some kind.
it's one
Like
of
you
those.
have to take accountability.
Yeah, exactly. Like I don't obviously look. I don't know Jisu. I don't hate her or have, and I don't wish any harm to come to her or anything like that. But at the same time, exactly, I'm with you right there. Like when I see people that do stuff like this so publicly, um, and they do it with what I would consider to be malicious intent, um, you have to pay for it. You know what I mean? You're going to pay for what you've done. I mean, you're the one that. There's a reason why there's a saying, "Don't start, won't be none." And it's just like you started this. You really did. Nobody said that you had to be the one to sit there and put out a document. And again, it's these people that are these online activists. They feel passionately about something, and they just want to they want to feel like they've affected some kind of change in the world. It's just like what does that change really matter in the long run if it's not based on any kind of objective truth or reality? You know what I mean? Or if you don't know if it's really based on objective truth or reality. In her mind, it's pretty obvious from this filing that she really believes this stuff, right? And remember, in one of her previous filings, she had said, "Hey, I didn't make up that lie about ZeRo. I just repeated it."
I just heard it from someone else. And
I heard it from somebody else.
And then when people said I was wrong, I continued to run with it, even though I could have just checked myself and like asked for permission. But it's not my fault.
Exactly. Yeah, and that's just wild to me. And it's just like, listen, you're saying stuff that could really affect a person's life and well-being, because it's not like just. I've talked about this before. A lot of times when it comes to online shit, it's one thing to sit there and call people names, right? Oh, you're a dick. Oh, well, you're an asshole. Mm-hmm. Oh, or you're a mean person. This, that, or the other, right? And just dumb shit, right? That's whatever. That doesn't really or you call somebody a liar. Well, you're a liar. Well, you're a liar. Well, whatever.
Dishonest.
You're dishonest. Little squabbles like that are one thing, but when you're calling somebody something as heinous as that, right?
Yeah, actual criminal
as a pred,
activity.
Yeah, alleging that somebody has done something that criminal, and you don't really have anything that substantiates that outside of some person's word and some really questionable evidence, right? Because and that's the thing that drove me crazy about a lot of these people that talked about it. Look at what he's saying here. I'm like, what is he saying there? You know what I mean?
Yeah.
It's just like, yeah, it doesn't look appropriate, but is it what you think that it is? It's just like, and I would argue, unless you have something more, like, I don't think we'd be here right now, right? Franchise, if ZeRo had said, hey, why don't you take off your clothes and, touch yourself and shove your fingers into your thing. And, if we actually saw that, right?
Yeah, if those were it would have been,
It's a completely, it's a completely different ball game at that point. It's like,
there's no
that's
lawsuit.
Yeah,
Maybe maybe Jisu and Leffen take some heat, but it's like,
Yeah, but if we were to go ahead.
Even if it was the allegations completely true, it was still made by Katie. It wasn't made by Jisu and Leffen, so they could still catch heat for like trying to ride the bandwagon.
Yeah,
but it probably wouldn't get as far.
Yeah, but I mean, if you had something like that that's a little harder to explain away, it's just like, you know what I mean? Then it's like more understandable. But it's like you see stuff and it's just like, well, he means this. It's like, but does he though? I mean, I could see where you could look at that and it looks like some of the things are said and it looks really suggestive. And I'm just like, maybe, yeah, I could see a case for that. And I would argue, yes, that it's not appropriate. It's probably not appropriate to be talking to somebody with this way. But without the full context of those messages, because for all we know, the very next message could show that the conversation you're seeing, right, in its full context, is something that's really innocent and harmless. By the very next message, right, was something that is said. So again, and I understood all the people that were talking about it. I understood their concerns with this. Like, oh, but look, he has to mean this. I'm just like, well, I mean, you don't know that. You still don't know that. Well, you're being, and I was told, I remember I was told by Willie, and I like Willie Mack, but he was saying, I think you're being too charitable. And it's funny because I've seen a lot of people be charitable towards things that I would say are much more salacious than what ZeRo has said.
Like in terms of like concrete proof, I'd argue Zaptide's worse than ZeRo.
Yes,
just
that's
personally.
What I'm saying.
I don't think Zaptide should be like deplatformed. I don't think he's like a pedo or anything. But
no, I don't think so either. I don't think he's a criminal or anything.
I think people are extremely charitable to him when they're not in other situations.
Mm-hmm.
I think like the Zaptide treatment should just be the treatment for a lot of other situations.
Yeah,
that's just not.
Yeah, like I said, look, if we had a DM of ZeRo saying the Ice Cube thing, right? It's like, ooh, it's
indefensible.
Yeah, and it's one of those things where you look at it, it's just like, well, how much more context you really need there? That's pretty.
Yeah.
You know what I mean? Because there's some things that obviously don't require a whole lot of context. It's just like sometimes there's enough context, right, with certain things that are said, right? But when they're very vague or very, like I said, they just are seemingly suggestive, but not necessarily suggestive. It's one of those things. It's just like, well, we'd have to see more of what's being said here. What's this conversation? What was said before this? What was said after this? What is this all about? One of the things in there was a quote from frickin' Percy Jackson, right? And it's just like, well, that could be completely harmless. You're taking it as something that's really like. They took it as something like really sexually suggestive. It's just like if it's a direct quote from something, which I don't know if it is or isn't, because it's
I think it's at the very least a reference.
It's a reference, and it's just like that could be harmless. You know what I mean? Mm-hmm. Thank you, GG Evans, for the 5. Appreciate it, buddy. If they want to change the world in any meaningful way, they can always be one less mouth to feed. Also, Vito Gasaldi is a suspected pedophile. I don't know about anything about that, but I've seen like some of the stuff that dude is wild. Vito,
Yes.
I feel I feel like some of the stuff that he says though, and some of the things he does are performative to a degree.
Yeah, but
Um,
he's saying like he's gonna sue Mama Max for like defamation or slander or whatever. It's like if anybody thinks of you negatively, it's not because of Max. Let's just put it that way.
yeah, I think that's fair, right?
Most people came to that conclusion. Like I came to the conclusion that Vito was kind of weird before Mama Max.
Yeah.
Yeah,
Well,
so it's like
see, that's the thing. I think that too. I think he is odd. He is pretty weird. And again, I would agree with what you're saying. But I also think, but part of me also feels like, you know what, Vito, I feel like he's one of these guys that is, this is where he kind of is a little bit like Mr. Girl, right? I feel a lot of what he's saying and doing is performative. The difference though with him and Mr. Girl is with Mr. Girl, you know, there's always that little bit of, you know, that possibility that with him it could be real, even though I don't think that it is. But you know,
like, I think his whole content is just him trying to justify to himself that what he thinks and believes is okay.
Yeah. See, like with Vito, like I don't like with Vito. I feel it's completely performative. I don't think that Vito has a good poker face. I think he does stuff purposely to stir the pudding. I think he says and does things to purposely be controversial. For the sake of keeping himself in the conversation, keeping himself relevant. I really do. I think he does that because if you've seen like Vito, he goes to a lot of people's live streams, man. He goes to a lot of different people's live streams, even people that are detractors of his. I would say are detractors of his or people that he's not necessarily friends with, and they allow him on. So it's just like, you know, I think, you know, look, if that's his hustle, you know, I guess not a bad way to stay relevant, but I just don't think that it's, again, I never think it's a wise choice to, especially on this site, to have this whole, well, we gotta be okay with Preds and stuff like that. We gotta be like, you know, sympathetic towards them and try to, you know, not be so mean to them and stuff like that. It's like, why would you want to die on that hill? You know what I mean? It's just like, especially on YouTube, it's just like, why? It's just like, I've seen so many people, like, you saw the guy, like the corporate citizen guy, right? The guy who said that he could relate to R. Kelly. Do you remember him? Do you remember hearing about him?
I think so.
He was the guy that made the video, like, that he could relate to R. Kelly and stuff. And then he told the story about how he basically, when he was in his 30s, and when he was like, you know, like 32 or 33 or something, was sleeping with this girl, and then he found out that she was a minor, but still kept sleeping with her anyways. And it's just like, dude, why would you put that out there? And the thing is, afterwards, he tried to say that it was all one big social experiment, although he didn't deny that the whole story with the girl was false. He said that was still true, though. And it's just like, bro, like, this is the dumbest social experiment.
Rap snitch to niches.
Yeah, it's just like,
friggin'.
It's just like, why
sit in the court and be their own star witness, dude?
Bro, it's so dumb. It's just like, why would you paint a target on your back like this? And here's the thing: when he did that, dude, like, there's to this day, he's changed his channel name like 3 or 4 times since then, because he still gets people that show up in his chat, in his live chat, that still call him a pred and a pedo and stuff like that. I'm like, bro, you kind of put yourself in this position for what? I don't know, for a social experiment that what? Like, to get more attention for yourself, I'm like, this is the stupidest fucking plan I've ever heard. So, anyways, we'll go ahead and start wrapping it up here, man, because I think we've said all we can say about this. I know there's another hearing that's going to be happening in September. We'll see where we're at that point, if they've reached some kind of settlement. What do you think is what's your prediction, though? What do you think is going to happen? Do you think they'll reach that settlement?
I predict settlement.
You think it will?
Jisu just can't fight it.
Dude.
Just she doesn't have the money.
You know, I almost, you know, for the sake of it, selfishly, and I'm just being real, I almost kind of would love it to go to court just to, you know, just to see what happens. But at the same time, you know, look, you know, Jisu's best bet is to settle. But it would be interesting to see how this would play out in court. I got to be honest, you know, it's my own like my own desire, a little bit of my own desire to see how it play out in court, but selfishly. But look, if it ends, it ends. But man, the other thing too, at the very least, I would like it to get to the point of discovery because I would really love to see what the discovery would look like in this for both sides. So, but we'll have to wait and see. So we'll go ahead and wrap it up here. Fran, thank you for joining me, buddy. If you can stick around for like 2 minutes afterwards, because I gotta tell you something real quick. But thank you to the rest of you that joined me tonight here. Mike Zeno, BMA Joe, Chaos Emblem, Italo, GG Evans, thank you. You are the stream daddy. I appreciate you, buddy. Zombie Fox, Jessica Foss, a couple more shout outs here. Kayla May. What else did we have here? Zucchero, thank you for joining. Namdam. If I didn't say, Nazand, of course. Sean Albert Renedy. If I didn't say your name, I apologize. Thank you for joining, though. I appreciate each and every one of you. I'll be looking to see. I'll be more on top of this to see when something else of significant drops. So be on the lookout for that. Thank you again, franchise, for joining me. You all have a wonderful night. I will catch you all on the next one.